The Contract Disputes Act of 1978. The Contract Disputes Act of 1978 is the authority which establishes procedures and requirements for resolving contract claims. The Contract Disputes Act of 1978 provides for the payment of interest on contractor claims, certification of contractor claims, and a civil penalty for contractor claims that are fraudulent or based on a misrepresentation of fact. When the government and a contractor cannot agree on the terms and conditions of a contract, the Contract Disputes Act, or CDA, provides a method for each party to resolve their disagreement. It's the government's policy to resolve all disputes by mutual agreement at the contracting officer's level. However, if a dispute cannot be resolved by mutual agreement, the contractor may submit a claim. Claims must follow the Contract Disputes Act as implemented at FAR Subpart 33. Jason and Charlie decide to sit together and learn 13 important facts, timelines, dollar limits, and other basic principles about the CDA. First, there must be either an express or implied contract. Second, a contractor's claim against the government must be submitted to the contracting officer in writing. Third, a claim by the federal government against a contractor must be made by issuing a contracting officer's written decision. Fourth, each claim, whether by the contractor against the federal government or by the federal government against a contractor, must be submitted within 6 years after the accrual of the claim, except for cases involving fraud. Fifth, for claims from the contractor over $100,000, the contractor must submit a certification stating that the claim is made in good faith. Sixth, after the government has received a contractor's claim, the contracting officer must issue a contracting officer's decision in writing. Seventh, for claims valued at $100,000 or less, the contracting officer must issue a final decision within 60 days from the date the claim was submitted. Eighth, for claims valued above $100,000, the contracting officer must issue a final decision within 60 days from the date the claim was submitted or notify the contractor when the final decision will be issued. Ninth, contracting officers do not have authority to settle, compromise, pay, or adjust any claim involving fraud. 10th, a contractor has the right to appeal the contracting officer's decision to an agency board within 90 days from receipt of the contracting officer's decision. 11th, the CDA authorizes a contractor and a contracting officer to use any means of alternate dispute resolution or other mutually agreeable procedures to resolve claims. 12th, interest due to a contractor for a claim shall be paid to the contractor beginning with the date the contracting officer receives the contractor's claim until the date which the claim is paid. The Secretary of the Treasury specifies the interest rate. 13th and last, contracts should generally not be that of the Tennessee Valley Authority, foreign government, international organization contracts, or maritime contracts. This was a lot of information for Charlie and Jason to absorb, so they take a break. In the next module, Charlie and Jason will take a closer look at claims and requests for equitable adjustment to decide which path they will take if they can't mutually agree on their contract dispute. See you soon!